The five-judge Constitution bench held that imperative education cannot be treated as trade or business in which one of the following case, Unni Krishnan case. In which one of the following case Supreme Court of India invalidated constitutional amendment for non-compliance with the procedure contained in the proviso of clause 2 of article 368 Khiloto Holhohan versus Jack Cool and others. Supreme Court of India, considering the validity of proclamation of emergency under Article 356, said that proclamation is a subject of judicial review in which one of the following case, S.R. Bommai versus Union of India. The Supreme Court of India said that it is not the duty of the court either to enlarge the scope of legislature or the intention of the legislature when the language of the provision is plain and unambiguous in which one of the following case, Union of India versus Devki Nandan Agarwal. The special bench of the Supreme Court is unanimous served that even petition filed under Article 32 of the Constitution of 32 are subject to the general principle of res judicata in the following case: M.S.M. Sharma versus Dr. Sri Krishna Sinha. The term law includes every branch of law. Yet, there is a difference between constitutional law made in the exercise of sovereign power, and hence an amendment is not covered within the definition of the law provided in Article 32, Clause 2 and 3 of the Constitution of India. This observation was made by the Supreme Court in Sankari Prasad versus Union of India. Justice Mukherjee CJ, speaking the court, stated that though the executive power is vested in the president is only a formal of constitutional head of the executive. The real power is vested in the Council of Ministers, on whose aid and advice of the president act in the exercise of his function. In the following case, Ram Javaya Kapoor versus State of Punjab. The right of a person to be appointed as a guardian of the minor children under personal law is not a fundamental right, was decided by Supreme Court in which one of the following case: Saifizada Saria Muhammad Ambri Abibas versus State of Madhya Bharat. Arrange the leading case or the pronouncement of the arrangement. P.A. Imandar in Amdad versus State of Maharashtra. I.R. Selio versus State of Tamil Nadu. Official liquidator versus Dayanand Selvi versus State of Karnataka. Chronological order: Usha Mehta versus Government of Andhra Pradesh. Baswa Raj versus Special Land Acquisition Officer. City Industrial Development versus Platinum Entertainment. Union of India versus N.S. Rathnam and other. Which one of the following case is not related to the theory of basic structure and Article 368 of the Constitution? T.K. Ranganajan versus Government of Tamil Nadu. Which one of the following case is not related to parliamentary privilege? State of Tamil Nadu versus K.M. Shyam Sundar. Judicial review or administrative action under Article 32 and 226 is a part of basic structure of the Constitution. It was held by Supreme Court is L. Chandra Kumar versus Union of India. The lab binding of the Supreme Court. The law binding by the Supreme Court is a binding on all of the court within the territory of India, but Supreme Court is not bound by its own decision. Was decided by Supreme Court in itself in the case of Bengal Immunity Company Limited versus State of Bihar. In which one of the following case Supreme Court held that placing ordinance before legislature is a mandatory repromulgation of ordinance in the fraud of the constitution? Krishna Kumar Singh versus State of Bihar. Re-Delhi Law Act case, Re-Bedubadi case, Re-Sea Custom Act, Keshwanand Bharati case. Chronology order of Article 143 of Constitution. In which one of the following case Supreme Court held that member of Parliament, member of Legislative Assembly, member of Legislative Council who is convicted of a crime can be given a minimum of 2-year imprisonment, loses the membership of the House with an immediate effect. Lily Thomas versus Union of India. Arrangement. Anwar Hussain versus Ajay Kumar. Vinod Kumar Santilal Ghoshal versus Gangadhar Narsingdas. Nizam Sudan Singh versus New Municipal Committee. Nizam Institute of Medical Science versus Parsnath Dhanak. In which one of the following case Supreme Court said that fundamental right and directive principle aim at the same goal, bringing the social revolution of establishment and welfare of the state. That was is interpreted by applied together, and they are supplementary and complementary to each other. Keswarat Bharati versus State of Kerala. Nobody can be above the institution which he is supposed to serve. He is merely a creature of the institution. He cannot exist only in the institution exists. To protect the individuality, he mightier than the constitution would be gave injustice. In which one of the following case Supreme Court through Chief Justice Sikri observed that TN Session versus Union of India. We have to evolve a new principle and law, laid down new norms which will be adequate deal with problems which arise the highly industrial society was add down in MC Mehta versus Union of India. A citizen has a fundamental right to use the best means of imparting and receiving information as such to have access and telecast for purpose is the observation of Supreme Court in Ministry of Information and Broadcasting Government of India versus Cricket Association Bengal 1995. In which one of the following case Supreme Court held that federalism in India is not a matter of administrative convenience but one of principle. S.R. Bommai versus Union of India 1994. In which one of the following case Supreme Court made the mandatory for candidate contesting election to the legislature and their spouse to declare their source of income at the time of filing nomination. Lok Prahari versus Union of India. In which one of the following case Supreme Court held that an intermediary shall be liable to the third party information hosted by him if upon receiving actual knowledge from the court order or being notified by appropriate government he failed to expeditious removal of the material. Shreya Singhal versus Union of India. In Raja Rampal versus Honorable Speaker Lok Sabha and other 2007, which one of the following was not issued before Supreme Court? Where right to speech and expression is inferior to the privilege of the member of the House. In which one of the following judgments Supreme Court explained the effect of 42nd Amendment on the protection available to civil servant under Article 331 of the Constitution of India. Managing Director Electronic Corporation of India versus Karunakar. In Madras Bar Association versus Union of India, Supreme Court declared that National Tax Tribunal 2005 is an unconstitutional on the ground that that it is encroached upon the inclusive domain and the superior court to record and principle of separation of power. The NJAC Act was declared unconstitutional in Supreme Court Advocate on Record Association versus Union of India, in which one of the following case notification of 4th March 2014 regarding Jat reservation was set aside. Ram Singh versus Union of India. The Constitution protection of Article 21 protected the right of person to fair trial is the law validate restriction operatively in the right of free speech under Article 19(1)(a) by the virtue of the force of constitutional provision, in which one of the following case aforesaid observation has been made. Sahara India Real Estates versus Security and Exchange Board of India. In which one of the following case Supreme Court struck down that Section 66A of Information Technology Act 2002, Shreya Singhal versus Union of India. In which one of the following case Supreme Court established the relationship between Article 14, 19, 21 of the Constitution, Maneka Gandhi versus Union of India. Supreme Court in State Training Corporation of India versus Commercial Tax Officer 1963 observed that company registered under Companies Act 1956 is in a legal person, but it cannot avail itself the fundamental right under the Constitution available to the citizen only. The right against self-incrimination under Article 20 Clause 3 and Section 161 Clause 2 of CRPC was recognized by Supreme Court in the case of Nandini Sampath versus PL Dani. Any member of Parliament MP, any member of Legislative Assembly MLA, member of Legislative Council MLC who is convicted for a crime for more than 2-year sentence will be disqualified as an elected representative on the date of conviction. In which one of the following verdicts Supreme Court opinion showed that sent the wave of panic amongst the government. Lily Thomas versus Union of India 2013. The constitutionality of Haryana Panchayat Raj Amendment Act 2015 was challenged in Raj Vallabh versus State of Haryana. In the recent case, Supreme Court held that transgender fall in the category of socially and educationally backward classes. CV. Nalsa versus Union of India. Point out the incorrect match. D is incorrect. G.K. Krishnan versus State of Tamil Nadu, Freedom of Trade. Jabbar Bhai versus State of Bombay, Repugnancy. State of Bombay versus F.N. Balsara, Doctrine of Severability. Catch-up rule in the relation of reservation is evolved in the Supreme Court in Union of India versus Virpal Singh. Point out incorrect match. D is incorrect. State of Karnataka versus MS Drive-In Enterprises, Pitham Substance. Asif Ahmed versus State of Jammu and Kashmir, Separation of Power. Tata Iron and Steel Company Limited versus State of Bihar, Doctrine of Territorial Nexus. The Union of India versus Sukumar Sen Gupta. Supreme Court stated that the agreement of 1972 and 1982 between India and Bangladesh concerning Teen Bigha did not require a legislative action. In which case the Constitutional Bench of the Supreme Court gave detailed analysis of the concept of compensatory tax. Jindal Stainless Limited versus State of Haryana. In which case Supreme Court held that non-compliance with direction given by the court in the matter beyond its jurisdiction does not amount to contempt of court. Union of India versus Prakash P. Hinduja. The confirmation of additional judge or a high court is a permanent judge of that court. on the recommendation of Chief Justice of India without consultancy with the Collegium has been valid by the Supreme Court in Santi Bhushan versus Union of India. The claim of member of scheduled caste and scheduled tribes in making appointment required to be taken into consideration consistently and mandatory effective in administration is provided under the provision of Constitution of Indian Judicial Pronouncement, Article 335 of Constitution of India, in which case Justice R.C. Lothi held High Court is not a subordinate court but Supreme Court has superior place in hierarchy. He furthered its Supreme Court cautious abstains for issuing the direction as such High Court and rather uses of alternate polite expression like we request the High Court and High Court to expedite to we trust and hope of the High Court will shall spell the contest and respect and regarding which Supreme Court has and have must the High Court. क्या है? Tirupati Balaji Developer Private Limited versus State of Bihar. Supreme Court of India in one case observed that Article 15 is the enabling provision and state government is the best judge grant reservation ST, SC backward class category in the post level graduate in admission and decision. It is not make a provision reservation in postgraduate level suffering infirmity. This observation is made by Justice P. Sathi Sivam in Dr. Gulshan Prakash case, in which case Supreme Court held that rule that though reservation under Article 16 Clause 4 should not exceed 50%, it is not necessary to put out the consideration certain extraordinary situation inherited to great diversity of the country of the people. Indira Sawhney versus Union of India, in which case Supreme Court for the first time laid down the two elements: connection must be real, not illusory, and liability sought to be imposed must be pertinent to the connection with regard to territorial nexus. Tata Iron Steel Company Limited versus State of Bihar. The decision of Supreme Court in R.C. Ponduyal versus Union of India dealt with states of Sikkim, in which case Supreme Court upheld the validity of constitutional amendment provided for reservation and promotion in certain category of person, M. Nagarajan versus Union of India, in which case Supreme Court has invalidated the constitutional amendment for non-compliance with the procedure contained in the proviso clause 2 of Article 368. Khito Holhan versus Jai Chullu. Incorrect match. A. Correct match are Rajasthan State Electricity Board concept of state G. Bassi Reddy Article 12. Bashirnath Foundation rights fundamental right. Bashirnath fundamental right. Incorrect. C. Jindal Stainless Steel versus Haryana State of Haryana freedom of trade. Jabbed Bhai versus State of Bombay repugnance. Rudal Shah versus State of Bihar compensation. Suit lie against the government of death injury caused by the person in political atrocity held in Saheli versus Commissioner of Police. Which one of the following case does not related to civil servant? D. Which is related to civil servant? Union of India versus Tulsi Ram Patel, J.P. Bansal versus State of Rajasthan, T.N. Rangarajan versus State of Tamil Nadu. Incorrect pair. D. Correct pair are L. Chandra Kumar versus Union of India Judicial Review. State of Rajasthan versus G. Chahwal Pith and Substance. Asif Hamid State versus State of Jammu Kashmir versus separation of power. Which one of the following observation was not made by the country through J.S. Verma in Nilavati Behera versus State of Odisha 1993. Doctrine of sovereignty immunity is not applicable in the case of violation of fundamental right. Which one of the following statement is not correct? A is not correct. It is correct. In Sikri Prasad versus Union of India, it was held that law in Article 13 Clause 2 does not include law made by the Parliament to amend the Constitution under Article 368. In Golaknath versus State of Punjab 1967, it was held that the word law in Article 13 Clause 2 include parliamentary law amending the Constitution. In Keswanand Bharati versus State of Kerala 1973, Golaknath case was overruled, in which case the validity of certain police regulation which without the statutory basis authorized the police to keep under surveillance the person whose name was recorded in the history sheet maintained by the police as a person who were or were likely to be habitual criminals was challenged under Kharar Singh versus State of UP 1963. Naziria Motor versus State of Andhra Pradesh, the court held that even if a bill which has received the assent of the President under Article 304B of the court can examine the validity of law on the ground whether it is reasonable and in public interest. In which one of the following case held that Supreme Court decided the reservations should be less than 50%? M.R. Balaji versus State of Mysore. Interpretive value of preamble is discussed in Re-Pirwadi Union. The Hoschers Pharmaceutical Limited versus State of Bihar made the law under the entry 54 list 2 and Center made the law under entry 33 of list 3. The law overlap. Will repugnance arise in the case if both A and B are satisfied? The law of the question of repugnancy under Article 254(1) between the law made by the Parliament and law made by the state legislature arises only in the case of legislative occupy the same field with respect of one of the matter enumerated by concurrent list. There has to be direct conflict between two laws. The opinion of amicus curiae in Aruna Ramchandra versus Sanguna by case was in the favor of passive euthanasia provided decision discontinue life support was taken by the responsible medical practitioner. In which one of the following case Supreme Court had decided the constitutional amendment was taken away abridged fundamental rights would be void, therefore forced Parliament to enact the 24th Amendment Act is Golaknath versus State of Punjab. There is no reason to compel non-smoker to helpless victim in the air pollution was held in Murli Astevada versus Union of India. Fundamental rights granted by Part 3rd of the Constitution of India cannot be waived by a citizen was held in the Supreme Court in which one of the following case Baseswar Nath versus CITER AIR 1959. Which one of the following is a case deal with the appointment of judges of the Supreme Court? Pre-presidential reference, in which case curative petition was innovated by Supreme Court of India. Rupa Ashok Hooda versus Ashok Hooda 2002. Which one of the following case is known as case for curie case? Raja Rampal versus Honorable Speaker Lok Sabha 2007. in which case it was held that Supreme Court and High Court can direct CBI investigation without the consent of state government. State of West Bengal versus Committee for Protection of Democratic Right 2010, in which case Supreme Court held that the mental privacy is a part of Article 21 of the Constitution. Selvi versus State of Karnataka 2010. Conclusive part of Article 31C and no law containing the declaration that it is given effective to such policy shall be called question in any court on the ground that it does not affect such policy was struck down by the Supreme Court in the case of Kesavanand Bharti vs. State of Kerala 1973. The concept of curative petition was applied to the Supreme Court in the case of Rupa Ashok Hura vs. Ashok Hura 2002, in which one the Supreme Court upheld the Aadhaar card is a certain government scheme. K.S. Puttaswamy vs. Union of India, in which one the Supreme Court upheld the Haryana Panchayati Raj Act prescribing minimum educational qualification for contest of election Panchayat. Raj Billa vs. State of Haryana, which one of the following judgment of the Supreme Court related to the right of the third gender. National Legal Service Authority vs. Union of India 2014, in which one of the following case Supreme Court of India held that right to life does not exclude right to die. Glan Kaur vs. State of Punjab 1996, in which case Supreme Court ruled that the defense in sovereign immunity is aligned concept of granted of the fundamental right. Nela Batti Behra vs. State of Orissa, in which case Article 3232D of Article 323B3D was declared unconstitutional, extent that excluding the jurisdiction of High Court and Supreme Court under Article 226, 227 and 32 of the Constitution. L. Chandra Kumar vs. Union of India 1997. The doctrine of occupied field was applied by the Supreme Court in the case of A.B. Krishna vs. State of Karnataka 1998, in which one of the following cases observed that there is a fundamental right to seek the right of strike. T.K. Rangananjan vs. State of Tamil Nadu 2003, in which one of the following case court declared that Clause 2 and 5 of Article 368 of the Constitution as unconstitutional. Minerva Mas vs. Union of India 1890, which one of the following cases related to doctrine of eclipse. Deep Chandra vs. State of UP, State of Gujarat vs. Ambika Mal, Dulare Lodi vs. Third Additional District Judge. According to the Supreme Court, a person belonging to non-reserved class transplanted to adoption by the marriage and conversion or any law, voluntary act and family belonging to reserved class does not become eligible and benefit of reservation either under Article 154 and Article 16(4) of the Constitution of India. Kumari Madhurai Patel vs. Additional Commissioner Tribal Department, in which one of the following case did the Supreme Court overrule the judgment of Delhi High Court declared that Section 377 of IPC is not unconstitutional. Suresh Kumar Kaushal vs. Anar and Naz Foundation and others. Supreme Court observed that noise pollution cannot be tolerated. Even such a noise pollution was direct result of the connected with religious activity in the case of Church of God, Food Gospel in India versus KKR Majestic Colony Welfare Association. State of Maharashtra versus Dr. Praful B. Desai. Supreme Court of India held that recording of evidence through video conferencing so long as accused or his pleader is present while recording as per the procedure established by law and is valid. In which one of the following judgment the scope of the writ of habeas corpus is widened. Sunil Batra versus Delhi Administration 1978. Supreme Court of India issued a direction of the central government is concluded the national survey and the drug abuse within the period of 6 months and the national plan of curbing increased use of abuse and substance of children within 4 months. Bachpan Bachao Andolan versus Union of India 2017. How many judges constitute the bench of Supreme Court? Bench in the case of Supreme Court Advocate on Record Association versus Union of India 2016, in which the constitutionality of 99 Amendment Act was declared unconstitutional. 5. The case of Markandak Katju versus Lok Sabha 2017 is related to freedom of speech and parliamentary privilege, in which case secularism was recognized as a basic feature of the Constitution of India. Ashar Bombay versus Union of India, in which case direction for improvement of condition in net and the home of mental ill person under the Person with Disability 1955, as well as psychiatric hospital and nursing home under the Mental Health Act 1987 was issued by the Supreme Court of India by Reena Banerjee versus Government NCT of Delhi in 2017, in which case Supreme Court of India held that there is no jurisdiction of primity, only the Brahman can carry out the necessary rites in the ritual prestation. And Adaitan V. Travancore versus Dev Swan Board 2002, in which case Supreme Court of India held that all prostitute and sex workers also have right to live with human dignity under Article 21. Buddhadev Karmaskar versus State of West Bengal 2011, in which case Supreme Court of India has issued the guideline for prevented custodian violence. D.K. Vasu versus State of West Bengal 1997. Supreme Court of India has directed the Law Commission of India to examine the various issues related to working of a tribal, including the desirability to providing statutory appeal directed by Supreme Court in the form of tribunal on issue not affected the national public interest and aspect of statutory frame in respect of tribunal in Gujarat Urja Nigam Vikas Nigam Limited versus Izzar Power Limited. In Das, former judge of Supreme Court of India was invited by Supreme Court to present his view. Soumya murder case, Justice Markandak Katju. In which one of the following case Supreme Court introduced a person of collegium system appointed and transfer of judges? Supreme Court Advocate on Record Association versus Union of India. What is the significance of Pravasi Bhalai Sanghatan versus Union of India? The case is result to the Law Commission of India has submitted report number 267 in March 2017, hate speech. In Das, the Supreme Court held that women can be arrested by police at any time, even in the absence of lady constable, if the arresting officer record the proper reason for such arrest. State of Maharashtra versus Christian Community Welfare Council of India. Selvi versus State of Karnataka is related to right against self-incrimination. Which one of the following judgment ruled by the Justice P.K. Puttaswamy versus Union of India 2017? Govinda versus State of Madhya Pradesh 1975. In which one of the following judgment it was held that jurisdiction conferred upon High Court under Article 226 and upon the Supreme Court under Article 32 of the Constitution of India, inviolable basic structure and the Constitution of India. L. Chandrakumar versus Union of India 1997. The National Judicial Appointment Commission Act 2014 was declared unconstitutional in the case of Supreme Court Advocate on Record versus Union of India. Which one of the following statement is incorrect in the view of Cultural Trust versus Union of India 2013? Article 15, insofar as it is applicable to the minority education institution referred in Article 31(1) of the Constitution, is ultra vires the Constitution. In which one of the following decisions Supreme Court framed a guideline for safeguard the interest of the death row convict Shatrughan Chauhan versus Union of India? Shatrughan. In which one of the following, where relevant, consider the prohibition prohibited by sale and liquor along national state highway in the state of Tamil Nadu versus Babu? There is no fundamental rights under Article 19(1)(g) of the Trade of Liquor, an exception to permit a sale of liquor along a stretch with passes through the limit of city arbitrary and voluntary of Article 14. Right to life under Article 21 signify right to live with human dignity, free of noxious and substance intoxicant. Which one of the following reasons lead to the setting aside of the practice of talaq-e-biddat, triple talaq, in Saida Bano versus Union of India 2017? Section 2 of Muslim Personal Law Shariat Application Act 1937 was pre-constitutional legislation within the meaning of Article 13(1) and violative of Article 14 of the Constitution of India on the ground of arbitrariness. Muslim Personal Law Shariat Application Act 1937 is not law regulating triple talaq, but practice of triple talaq was against the basic tenet of Holy Quran and not a practice against the tenet of Quran is permissible. Which is the correct position in the law of ordinance promulgated under Article 132 of Constitution of India? The following the judgment in Krishna Kumar versus State of Bihar. Power conferred upon the President under Article 123 of Legislative in character and satisfaction of the President to amend judicial review. The ordinance promulgated in the exercise of power under Article 132 create enduring right in the favor of individual. Reformulation of an ordinance is a fraud on the Constitution. In which one of the following case Supreme Court struck down the part of Constitution 43rd Amendment 1976 by Article 31(c) and the amendment? Minerva Mills versus Union of India 1980. In which one of the among the following case did not Supreme Court hold the petitioner have not a fundamental right within the meaning of Article 24 and 26 in perform of Tandav dance in a public street or private place? Quorum of Police Acharya versus Jagdish Nandan Avandutta. In which one of the following case Supreme Court issued the detailed direction for the protection of good and smatters? Safe Life Foundation versus Union of India 2016. In which one of the following case Supreme Court refused to give any relief to the petitioners under Article 32? Suresh Chandra Gautam versus State of Uttar Pradesh. Right to life include right of repetition was recognized in Dr. Subramaniam Swamy versus Union of India. Article 232 was introduced into the Constitution of India, validate the appointment of judgment etc. Deliver a certain district of judges. In which one of the following case where Those appointments invalidate the writ of quo warranto. Chandra Mohan versus State of UP 1966. In which one of the following case reservation for the Jat was struck down? Ram Singh versus Union of India 2015. In which one of the following case first before the Supreme Court of India where constitutionality of death penalty was challenged? Jagmohan Singh versus Union of Uttar Pradesh. In which one of the following cases did Supreme Court observe we cannot allow with judicial thinking to be constricted by reference of the law in prevail of the England or for a matter in any of the following country? We no longer need to clutch the foreign legal order. MC Mehta versus Union of India 1987. Supreme Court of India recognized transgender as a third gender with all rights in the case of National Legal Service Authority versus Union of India AIR 2014 Supreme Court 1863. In the Supreme Court, in that Supreme Court observed that what is practiced in our personal is a theory of retributive and deterrence of the ground and situation emphasizes this, while our criminal justice system believe in reformation and rehabilitation, and this is why handcuffing the solitary confinement are prohibited. It is the rejection of the philosophy of our criminal justice system lead to the violation of prison and eventually unnatural death. The Supreme Court highlighted the need of overhauling in order to ameliorate the condition of the prison across the country and thereby reduce the number of unnatural deaths. Inhuman condition in 1382 prisons. The decision of Additional District Magistrate Jabalpur versus Shivkant Shukla has been specifically overruled in Justice K.S. Puttaswamy versus Union of India. A law which disqualifies a person more than 2 children from holding the post of Panch and Sarpanch is valid and not violative of Article 14, in which one of the following case Supreme Court observed that Javed versus State of Haryana. In which one of the following case Supreme Court introduced theory of alternate institutional mechanism? SP Sampad versus Kumar, Union of India. The judgment of the Supreme Court in Natal Lal versus State of Punjab, the application of Clause 1 of Article 20 of the Constitution held that the said clause prevented retrospective operation only those criminal law in which are against the interest of the accused. In PUCL versus State of Maharashtra, Supreme Court has issued 16 guidelines regarding the investigation of encounter death. In which one of the following cases Supreme Court held that government employee can also file PIL, since right of judicial remedy is a constitutional right available to all citizens of India. Vijay Shankar Pandey versus Union of India. In which one of the following case Supreme Court has held in a strong word imposing mother tongue as a medium of instruction and violation of fundamental right. Associated Management of Government recognized unaided English medium primary and secondary schools versus Union of India. In which one of the following case Supreme Court upheld the citizens' right to negative violation? PUCL versus Union of India 2013. In which one of the following Supreme Court observed that regulatory measure and compensatory tax uses the trading faculty did not hamper the trade and commerce in the intercourse? Automobile Transportation Limited versus State of Rajasthan 1962. Jagmohan Singh versus State of UP 1973 established the award of this sentence is not violative of Article 21 of the Constitution. With the reference of constitutionality of the Section 377 of IPC, in which one of the following cases it was observed that sex under Article 15 of the Constitution includes sex orientation. Naj Foundation versus Government of NCT Delhi. Delhi Law Times. Match the list. Right to live with human dignity enshrined in Article 21 derive life, breath and directive principle of state policy in clause E and F of Article 39, 41 and 42. Bhagwati J. in Bandhua Mukti Morcha versus Union of India. Speedy trial. Speedy trial is an essential ingredient of the fair and reasonable procedure granted by Article 21. P.N. Bhagwati in Husna Ara Khatun versus State of Bihar. In PIL, total stranger to a trial cannot permitted the question of correctness and conviction of the accused. Ahmadi J. in Sri Simranjit Singh versus Union of India. In the case of helplessness and desirability, any medium of the public can maintain the appeal approached order direction rate in their violation of constitution. And Bhagwati Jain SP Gupta versus Union of India. Doctrine of Weber Bhaskaran Nath versus CIT. Doctrine of Phillips Bikaji versus State of Madhya Pradesh. Doctrine of Severability State of Bombay versus FN Balsara. Doctrine of Repugnancy Kesariya Hind Private Limited versus NTC. Reservation in unaided private college PA in Nandar versus State of Maharashtra. 27% of reservation in OBC of the service. Indra Swani versus Union of India. Constitutionality validity include 9th schedule. IR Celio versus State of Tamil Nadu. President is a formal head of the government of India. Article 79. Actual executive power of Union of India with the Council of Ministers. UN Rao versus Indira Gandhi. Presidential election dispute is and unaided by the Supreme Court. Article 71. Presidency is a part of Parliament. Shamsher Singh versus State of Punjab. Vineet Narayan versus Union of India. Curative petition. Continuing mandamus. Kunal Singhal versus TM Darjeeling. Habeas corpus. Rupa Ashok Hura versus Ashok Hura. Curative petition. L. Chandra Kumar case. Administrative tribunal. Judicial review. Keswanand Bharti versus State of Kerala. Free and fair election. Indira Gandhi versus Rajnan. Balance of Part 3 and Part 4. Minerva Miles versus Union of India. Secularism. S.R. Bommai versus Union of India. S.R. Bommai versus Union of India. Article 356. P.V. Narasimha Rao versus State. 105. ADM Jabalpur versus Shivkant Shukla. Article 21. Lily Thomas versus Union of India. Article 44. S.R. Chaudhary versus S.R. Chaudhary's case. Non-member cannot be reappointed as a minister if he failed to get elected after 6 months. Murli Devra case. Ban on smoking at public place. Association for Democratic and Reform case. Electorals have fundamental right and non-accident of contesting candidate. PUCL case. Right of the food is a fundamental right under Article 21. Golaknath versus State of Punjab. Prospective overruling. Olga Tellis versus Municipal Corporation of the Right to Livelihood. TMA Pi Foundation versus State of Karnataka. Minority Educational Institution. Keshav Madhav Menon versus State of Bombay. Doctrine of Eclipse. Freedom of speech and expression. Bennett Coleman versus Union of India. Basic feature theory. Keswanand Bharti versus State of Kerala. Freedom of movement and right of personal liberty. Menaka Gandhi versus Union of India. Independence of judiciary. SP Gupta versus Union of India. Advisory opinion of the Supreme Court also binding on all court. In reference to the Special Court Bill Act 1978. Basic structure of the Constitution cannot be amendment. Keswanand Bharti versus State of Kerala. Presidential satisfaction under Article 356 of judicial review is limited extent. S.R. Bommai versus Union of India. A law made by the legislature is deprived of person of his personal liberty must be just and fair, reasonable. Menaka Gandhi versus Union of India. Alternate dispute resolution. Afro Quans infrastructure. Right to educational limited case. Unication versus Union of India. Right against self-incrimination. Nandini Sampath case. Solitary confinement. Sunil Batra case. K. Puttaswamy versus Union of India. Right to privacy. Saida Bano versus Union of India. Tirupal Talaq. Navjot Singh Johar case. Sexual orientation. Joseph Shine versus Union of India. Adultery. K.C. Vastavan Kumar versus State of Karnataka. Reservation on backward classes. Paramanand Katra versus Union of India. Fundamental right to life and personal liberty. A.S. Narayan versus State of Andhra Pradesh. Religious freedom. Katoya versus Jekolia. Doctrine of severability. Keswanand Bharti versus Union of India. 1973. Indira Gandhi versus Raj Narain 75. Minerva Miles case 1980. State of Bihar versus Bal Mukund Shah 2000. S.R. Bommai case Article 356. P.S. Narasimha Rao case Article 105. ADM Jabalpur case Article 21. Lily Thomas case Article 44. Right to go abroad Menaka Gandhi case. Right to livelihood Olga Tellis case. Right against sexual harassment Vishakha case. Right of education Mohini Jain case. Doctrine of eclipse Bikaji versus State of Madhya Pradesh. Doctrine of severability RMDC versus Union of India. Doctrine of waiver Bhaskar Nath versus Income Tax Commission. Doctrine of Pith and Substance. State of Bombay versus F.N. Balasara. Article 329. Indira Nehru Gandhi versus Raj Narain. 10th Schedule Part 7. Kotahia Jakchulla. Article 31. Shigola Keswanand Bharti versus State of Kerala. Article 13.2. Golaknath versus State of Punjab. Equal work for equal pay. Randhir Singh versus Union of India. Agencies instrumentally and state are covered under the definition of state under Article 12 of the Constitution. R.D. Sethi versus International Airport Authority of India. Fundamental rights and active principle of state policy are supplementary and complementary to each other. Unni Krishnar versus State of Andhra Pradesh. Damage can be awarded in the violation of fundamental right under Article 21 of the Constitution. Rudra Shah versus State of Bihar. Compensation to person killing in fake encounter. People's Union for Civil Liabilities versus Union of India. Compensation for rape victim. Delhi Domestic Working Women Forum versus Union of India. Interim compensation of the rape victim. Bodhisattva Gautam versus Subhra Chakrabarti. Protection against the illegal arrest and detention. Jogendra Kumar versus State of UP and custodian death. Right to speak include right not to speak. Bikaji Emmanuel versus State of Kerala. Government has no monopoly in the electric media. Secretary Minister I&B Cricket Association of West Bengal. Commercial advertisement is a part of freedom of speech and expression. Tata Press Limited Mahanagar versus Telephone Nigam Limited. Government cannot impose prior restraint on the publication of defamatory material against the official. R. Rajgopal versus State of Tamil Nadu. S.R. Choudhury versus State of Punjab. State of Punjab. Non-member cannot be reappointed as the minister if he fail to get elected within 6 months. Murli S. Devra versus Union of India. Ban on smoking in the public place. Food Corporation of India versus Bhagirathi Khediya Nigam Kamchari Sangh. 2 extra increment in existing employee on earning higher qualification. Javed versus State of Haryana. Classification based on the number of children for elected in the post of Panchayat. Hari Krishna Bhargava versus Union of India. Power of Parliament to levy tax on income tax other than the agriculture income. Godfrey Phillips India Limited versus State of UP. Principle of interpretation of avoid overlapping. K.C. Ganpati Narayan Dev versus State of Odisha. Level legislation. In Delhi Law Acts. Conditional legislation. In which one of the following case Supreme Court of India decided there is no fundamental right of education for a professional degree that follow from Article 21. Balbir Thomas versus Center for Cellular and Molecular Biology. Maharshi Avdesh versus Union of India. Uniform Civil Code. Kacha Jai Sankat Narivan Samriti versus State of Gujarat. Common God. M.H. Hoskot versus State of Maharashtra. Legal aid. State of Punjab. State of Uttar Pradesh versus Pradhan Sangh Khesari Smriti. Organization of Village Panchayat. Rajesh Gupta versus State of UP. Reservation to women. Attorney General of India versus Lakshman Devi. Executive death of public by hanging. Avinash Malhotra versus Union of India. A right to safe education. Vishaljit versus Union of India. Trafficking in human being include Devdashi. A.C. Joseph Shine versus Shivan Pillai. Uses of electronic evidence for casting vote. S.S. Dhonal versus Union of India. Power of Electoral Commission. Electoral Commission होगा. Digvijay Motor versus Union of India. Postponement of election on the account of disturbance condition. People Union for Civil Liabilities versus Union of India. Provision of nota. Indira Nehru Gandhi versus Raj Naren. Rule of law. Kulpali Nageswar Rao versus APSRTC. Departmental bias. Fagu Shaw versus State of West Bengal. Preventive dissension. Upendra Basi versus UP. Right of imitate in protective homes. Keswanand Bharti versus State of Kerala. Basic structure doctrine created. Indira Nehru Gandhi versus Raj Naren. Basic structure doctrine strengthened. Minerva Vance versus Union of India. Basic structure doctrine crystalled. Iyer Celio versus State of Tamil Nadu. Basic structure doctrine new dimension added. The principle of constructive res judicata is applicable to the petition. Women's Education Trust versus State of Haryana. Writ petition dismissed. Want of prosecution can be restored. M.S. Naga Bhushan versus State of Karnataka. Direction given by High Court under Article 226 of the Government of India. Ratan Singh versus State of Rajasthan. The disposal of several writ petitions in the batch of single order would be permissible if fact of all cases are similar and almost similar. V. Pro Kuttu Mandisror versus State of Kerala. K.M. Nanavati versus State of Bombay. Power to pardon. Ram Prasad versus Union of India. Fundamental duties. Lily Thompson versus Union of India. Disqualification of member. D.N. Dr. P. Nallad versus Thompson Tehri Union of India. Right to life. Union of India versus Sakal Chand Seth. Appointment, transfer of judges. Leela David versus State of Maharashtra. Power to punish contempt. BSES Limited versus Fenway Limited. Foreign precedent. Darshan Gupta versus Radhika Gupta. Power to competent justice. M. Nagarjun versus Union of India on capitation fee. Indra Swani versus Union of India to provide reservation in the promotion of scheduled castes and scheduled tribes. Moni Jain versus State of Karnataka. Application in creamy layer and OBC. N. Roy versus Union of India. Case of national security. KLNV Veena Genuoli versus Union of India and others. Every author has fundamental right to speak out idea fairly and expressly without advocate. Abhiram Singh C.D. Coleman dead versus IRS. Seeking vote in the name of religious caste and corrupt practice. Pawan Kumar versus State of HP. Women right to love and reject. Bio Longus dead through LRS. State of Assam and state is not empowered to create office in the parliamentary secretary. Appointment of the judges of Supreme Court. Supreme Court Advocate on Record versus Record Association versus Union of India. Just jurisdiction of Supreme Court as a court of record. State of Karnataka versus Union of India. Original jurisdiction of the Supreme Court. In Re Vinayak Chandra Mishra. Power of Supreme Court to withdraw and transfer of credits. A.R. Anayatullah versus R.K. Nayak. Re Special Reference number 1 of 2012. Allocation of natural resources. Abhiram Singh versus C.D. Codeman 2017. Prohibition of appeal election on the ground of race, caste, community and language of the candidate. Krishna Kumar Singh versus State of Bihar 2017. Power of the President under Article 123 of the Government under Article 213 Promulgate Ordinance. National Legal Service Authority versus Union of India 2014. Right of third gender. ADM Jabalpur versus Shukla. Habeas corpus case. M.S.M. Sharma versus S.K. Sinha. Searchlight case. R.C. Cooper versus Union of India. Bank nationalization case. R.K. Garg versus Union of India. Bearer bond case. Right to go abroad. Maneka Gandhi. Prisoner right. Sunil Batra. Death penalty. Bachan Singh case. Government liability. Bhim Singh case.